or today we are more predominantly active, but still there are shortage of activities in this arena. The reason being is that the way we are shaped up for Indian Evidence Act 1872 and the component that are covered in evidences, we require some form of human being as a part of evidence. Understand one perspective that if I look at computer system, if it is silent, will it on its own be able to do or create any kind of crime? No. The device in itself is incapable of handling or carrying out any type of criminal activity. This is the core base where the Indian cyber lawmakers or the evidence makers have addressed to. If you look at the kind of legal framework we had, whether it's a RBI guidelines for banking or Evidence Act or the Companies Act or any of the scenarios, we have bought it through Britishers, through lot of cases and evidences on arguments that were supposed to happen. The laws have been formed. So if you have to fight any type of criminal case or civil suit, what is the prevalent case earlier in a similar scenario? Similar and exact are two different things. A similar scenario can exist between two cases with minute modification. What is the interpretation a law would allow a person to defend himself? How it is interpreted, that is what is defined here. That's where we come across that evidences are of far more importance, whether it's an general case, a criminal case or civil suit, that is applicable even in the environment of cyber law. So in the environment of cyber law, the let's start with the presentation. The main purpose of investigation of any crime is to collect sufficient and legally admissible evidence to ensure conviction of offenders. Coming back to our scenario, the list of evidences that are accepted, please, when I prepare the notes, I'll give to you. First and foremost, if whether it's a e-contract or any substantial form of communication, copies of email is important, which is permissible as a part of evidences. Then email header along with detail. So an analysis of email, that is important. Finally, details of attachment received with email, IP addresses of the owner. So if I am the owner of the system, I have an IP address of my own system. If required, for cyber cafe, ISP or company's email server logs. Finally, recording of CCTV and video cameras, digital signature or signature detail if required. Always remember that these are the some of the evidences which are permissible in Indian courts. Finally, server and router logs or any other information as a part of ETC. So when we say the main purpose of investigation of any crime is to collect sufficient and legally admissible evidences to ensure conviction of offenders. Requirement of evidence in cyber crimes are not different, but its nature has made collection of evidence as a specialized job. On this particular topic, we'll be covering maybe after slide 1 or 2, right? Evidence Act and rules already in existence were considered not sufficient. If you look at IT Act 2000, certain changes were required for the evidence part. So extensive changes to Indian Evidence Act 1872 were made. So what does an evidence means? And includes all documents including electronic records produced in the court are called documentary evidence. Electronic records has the same meaning as assigned in IT Act 2000, that is, image or sound stored, received or sent in an electronic form, or microfilm or computer generated microfiche. Mark the word because it's a complete legal framework. You cannot miss out on words here. 17 point number Evidence Act 17, which was amended, admission defined. And admission is a statement, oral or documentary, or contained in electronic form. Can you mark the word contained in electronic form? Which suggests any inference as to any fact in issue or relevant fact. So idea here is that an admission is a statement, oral or documentary, or contained in electronic form, which suggests any inferences as to any fact in issue or relevant fact. So when we come across the digital evidences capturing that we do and the processes that are being defined, admission of an evidence will play a major role. If you look at last time when we were discussing the cyber cafe case, after finding the IP address of that particular device or the owner and searching for record, in the record what did they find? They did not find any measurable evidences to prove that a system has been used. The only admissible proof they had was the IP address allotted from the service provider to the cyber cafe. How much information received from accused may be proved when any fact is discovered in consequences of information received from a person accused in any offense in the custody of police officer. So much of such information as relates distinctly to the fact thereby discovered may be proved. Now, how much of information received from accused may be proved? Say somebody has accused about a thing, when any fact discovered in consequences of information received from a person accused of any offense. So here the person accused was whom? In the case earlier, if you have seen, what all evidences we are trying to gather? In the custody of a police officer. So an police officer went to that cyber cafe to find out information related to capture or create a particular case. So much of such information as relates distinctly to the fact thereby discovered and may be proved. When oral admission as to content of electronic records are relevant, 22A, mark that under Evidence Act 22A, oral admissions as to the content of electronic records are not relevant unless the genuineness of electronic record produced is in question. So when we say genuineness of electronic record produced in is in question, how does the electronic record will come? The email, the header, the IP address, all these facts has to be proved. Point number 59, proof of facts by oral evidence. All facts except the contents of document or electronic records may be proved by oral evidence, except the content of the document. Say if an email header to the person whom it is said, say maybe some kind of evidences has been gathered, whatever is content, whatever be the content, only those content, other any other thing may be proved by oral evidences. So when we say oral evidences, now let's look at the Cyber Cafe Pune case. The person who went there to investigate the case asked for certain procedures. Are you maintaining the records? Records of people who are there. Are you maintaining the logs? All these procedures were not there. So he made a statement in front of certain people, and that was admissible in the court. So when the court allotted certain punishments to him, only non-maintenance of certain documentation was relevant here. How much evidence to be given when statement forms part of electronic record? When any statement of which evidence is given forms a part of electronic record, then evidence shall be given of so much and no more of the electronic record as the court considers necessary in that particular case to the full understanding of the nature and effect of the statement and of the circumstances under which it was made. Now, when we say how much evidence has to be given, so any statement of which evidence is given forms a part of electronic record. Say if an email fraud has happened or some kind of activity has happened and we are trying to trace the hard disk, the image in the hard disk should be sufficient enough that court should consider necessary in that particular case to the full understanding of the nature and effect of the statement. Say if you are saying that based on these evidences we are suggesting that an act of this nature has happened. So when we do the forensic analysis or when we do the mail header analysis, when we check for a router, when we check for router logs or server logs or mail logs, these all documents should relate to the statement that has been made. Opinion as to digital signature were relevant. Now comes the main question in electronic digital evidence is digital signature. 47A section, when court has to form an opinion as to the digital signature of any person, the opinion of the certifying authority which has issued the digital signature has digital certificate is a relevant fact. When digital signature, when is the digital signature relevant? For the court opinion of the certifying authority or the issuer of digital signature certificate is a relevant fact. And proof as digital signature will cover under 67A except in the case of a secure digital signature if the digital signature of any subscriber is alleged to have been fixed on an electronic record. The fact that such digital signature is the digital signature of the subscriber must be proved. So what does it means? Now if a digital signature is valid for 5 years, then we have to prove that all the document or all the statements that content in that particular digital signature, right? Understand the language here, slightly difficult, except in the case of secure digital signature, if the digital signature of any subscriber is alleged to have been affixed on electronic record, the fact that such digital signature is the digital signature of the subscriber must be proved. Means if a person A has got a digital signature, he has signed certain document using his digital signature, then electronic record must prove that this digital signature is of the subscriber. You have to prove that. So proving that, then certain back records from where the procurement has happened, who was the certifying authority, what records he had, are those records matching of the digital signature, then that will be considered as a proof of digital signature. Proof as to verification of digital signature. Now if you have to prove about the verification of digital signature, what it has to contain under section 73A, in order to ascertain whether a digital signature is that of the person by whom it purports to have been affixed, the court may direct whom that person or the controller or the certifying authority to produce the digital signature certificate. Okay, that is very straightforward. Any other person to apply the public key listed in the digital signature certificate and verify the digital signature purported to have been affixed by that person. So any other person to apply the public key listed in the digital signature certificate. Say suppose I am the accused or say I am the victim, then I'll have to prove that this public key by any other person, right, who has uh, and verify that digital signature purported to have been affixed by that person. Say suppose I am using the digital signature of the same certifying authority, I'll have to prove that this public key for this from this certifying authority proves that this digital signature has been given from certifying authority itself. So there are two people required for verification of digital signature. One, the controller or CA. Second, some other person who has used or applied the public key listed in the digital signature certificate. Now, admissibility of electronic records. When we say admissibility 65B1, any information contained in an electronic record which is printed on a paper, stored, recorded, or copied in optical or magnetic media produced by the computer shall be deemed to be also a document if certain conditions are satisfied. Now, understand thing 65 says any information contained in electronic record, any form of electronic record printed on the paper. If it is printed on the paper, stored, recorded, or copied in optical or magnetic media produced by computer, shall be deemed to be also a document if certain conditions are satisfied. Secondly, it shall be admissible in any proceedings without further proof or production of the original as the evidence of any content of the original or any fact stated therein of which direct evidence would be admissible. Now, it shall be admissible in any proceeding without further proof. This is a very common statement that's happening, or production of the original without further proof. Say certain things has been admissible as a part of proceedings without further proof or production of the, so asking for any other proof or original, this is something that you'll have to give as a part of evidence. But in this case, it is admissible in any proceedings without further proof, means not asking for any further proof or production of the original as evidence of any content of the original. Understand, as evidence of any content of the original or of any fact stated therein of which direct evidence would be admissible. So how do you understand the email address, the IP addresses, the email header going from the server records, if these things are admissible as a part of electronic record as well. 65B, the condition are as follows. Remember that we were on 65B1, now 65B2. The condition are as follows. A, the computer output was produced. Understand? The computer output was produced during the period when it was used regularly to store or process information for the purpose of any activities regularly carried out on by a person having lawful control over the computer. Now it means that computer output was produced during the period when it was used regularly to store or process information. Point number B, during the said period, information of the kind contained in the electronic record or of the kind from which information so contained is derived was regularly fed into the computer in the ordinary course of the said activities. So the idea was that if some tampering has been done with the kind of devices, computer, when it was during that particular period when the computer was regularly used to store or process information, that will also be allowed. Secondly, during the said period, information of the kind contained in electronic record or of the kind from which information so content is derived was regularly fed into the computer in the ordinary course of the said activity. In the ordinary course of said activity, on a regular day-to-day activity, if some day-to-day work, that is called as ordinary courses in the court of law. 65b2 continued. C. Throughout the said period, the computer was operating properly, or if not, means on the particular set period computer was operating properly, or if not, then that part of the period was not such as to affect the electronic record or the accuracy of its content. So one consideration is that during that period computer was operating properly. If not, then that part of period which was not such as to affect electronic record or the accuracy of its content. So if there is some issue with the record as of today, in that particular period computer was operating properly. If even if it was not, in the event that for that particular period the content of the accuracy of the content of electronic record was valid. Point number D, the information content in the electronic record reproduced or is derived from such information fed into the computer in the ordinary course of the said activity. So the information content in the electronic record is reproduced or is derived from such a information fed into the computer in ordinary course of activities. Presumptions as to electronic agreement. 85A. The court shall presume that every electronic record purporting between an agreement containing digital signatures of the parties was so concluded by affixing the digital signature of the parties. What are the presumptions to electronic agreements? The court shall presume that every electronic record purporting to an agreement containing digital signatures of the parties was so concluded by affixing the digital signature of the parties. Means the digital signature, that is either you take symmetric or asymmetric signature, the certifying authority with their public key and private key, between the parties the agreement was happening. Secondly, 85b1, the court shall presume that secure electronic record has not been altered since the specific point of time to which secure status relates. So if there is some evidence is happening, the court shall presume secure electronic record has not been altered since the specific point of time to which secure status relates. In the proceedings involving secure digital signature, the court shall presume that secure digital signature is affixed by subscriber with the intention of signing or approving the electronic record. Mind it, in proceedings involving secure digital signature, the court shall presume that secure digital signature is affixed by the subscriber with the intention of signing or approving. Say somebody can dispute that it was not intended to sign. These statements will create certain facts about it. Once again, moving 88A, the court may presume that an electronic message forwarded by the originator through an electronic mail server to the addressee to whom the message purports to be addressed corresponds with the message as fed into his computer for transmission. Right? So the court would presume that electronic message forwarded by the originator to the addressee, but the court shall not make any presumption as to the person by whom such message was sent. So if there are authorized people or some communication has been happening between the originator, the court shall not make any presumption as to the person by whom such message was sent. So the person can be anybody. 90A, where any electronic record purporting or proof to be 5 years old is produced from any custody which the court in the particular case considers proper. The court may presume that the digital signature which purports to be digital signature of, yes, Krupali has raised hands. What is it? Somebody has raised hand. What is the what is the issue?
Nothing, sir. You can continue.
Okay. So, as per section 90A, where any electronic record, understand, purporting or proved to be 5 years old, right, is produced from any custody which the court in particular case considers proper, the court may presume that digital signature which purports to be digital signature of any particular person was so affixed by him or any person authorized by him on his behalf. So a digital signature generally, either in a proprietary case or a organization, there are people authorized to use that digital signature. This is under section 90A of the Electronic Act, Evidence Act will come into picture. Now, recent amendments that has happened, IT Bill 2008, Bill number 96F of 2008 was passed by Lok Sabha, Rajya Sabha. You must know it. I am sharing it for information. Now, important amendments to IT Act. In section 43, two new offences has been added. Again, we were moving to Digital Evidence Act. This will cover it. This screen will be in front of you. See, if we go back to IT Act 2000, right? Section 5 of IT Act 2000, legal recognition of electronic signature. The purpose of electronic signature, where any law provides that information or any other matter shall be authenticated by affixing the signature, or any document should be signed or bear signature of any person, then notwithstanding anything contained in such law, such requirement shall be deemed to have been satisfied. Now, if such information or matter is authenticated by means of electronic signature affixed in such a manner as may be prescribed by the central government, the idea is, for the purpose of the section, signed with its grammatical variation or cognate expression shall with reference to a person mean fixing his of his own handwritten signature. So when we say digital signature, we are talking, we also consider that that particular record, if it is printed, then it is assumed that it has been handwritten and hand signed by the people. When we say proof of electronic mail, so what all requires, if we have to submit the proof of electronic mail, IP address of the email ID creation, IP address of email sender, and IP address of email receiver. So email as electronic record, what it will require under the evidences: email of the sender, email ID of the creation and receiver. Point number one. Evidence of the sender of the electronic message if different from the author, right? Evidence of the sender. So suppose in an organization there are hierarchy of people, the sender might be different, correct? So the author could be a different party, the sender could be a different party, but within the same organization. Proof showing that electronic message was sent by the originator to the email address of the addressee. So email evidences, what it will require, proof showing that electronic message was sent. How do we show that? That is the header or email server log records. The acknowledgement, if any of the receipt of the electronic message by the addressee, if somebody has acknowledged that we have received the mail, yes or no. Proof of the receipt of electronic message generated from the target computer. Say suppose somebody is denying the fact, but on his mail server or his computer, this particular mail has been received, some kind of proof of that. Additional proof of email address of the originator through the documents such as previous correspondence etc in which the originator has stated the email address. So if there is some communication of agreement happening, if electronic mail as a record has to be proved, these are important things. Other corroborative evidences, direct or circumstantial. When we say direct or circumstantial means, suppose some tampering has been happened with mail server for deletion of records or all these things, direct evidence or circumstantial evidence has to be given. Now, how do we understand that the authority would talk on the particular electronic evidence? How does it happen? Because all this evidence collection happens at cyber forensic labs. So we have cyber forensic labs at Hyderabad, Trivandrum, Delhi, Himachal, Ahmedabad, and Mumbai. So under Section 45A of Indian Evidence Act 1872, 45A, when in a proceeding the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of examiner of electronic evidence referred to in the section 79A of the Information Technology Act 2000 is a relevant fact. So when we are talking about examiner of electronic record, correct? Now we are moving to I think we have covered copies of email header, details of attachment received on the emails, IP addresses of the owners, certain other substances. We can move ahead with the presentation part now. So in section 43, two new offenses have been added: destroying, deleting, or altering information in a computer resource to diminish its value. And second, stealing, concealing, or destroying any computer source code with intention to cause the damage. This we have already covered earlier. Again, 66A has come in. Here has section 66 has been replaced, providing that if any of the acts mentioned in section 43 was done dishonestly or fraudulently, it is punishable with 3 years. That is fine. A new section 66A is added, providing 3 years of imprisonment and fine for sending offensive, menacing information, false information, or causing insult and injury. These things I think we have covered earlier. Then uh, section 66B, and dishonest use of electronic signatures, password, or identification we have covered here. Impersonation, violation of privacy, which is almost new. Then cyber terrorism has come in. Obscenity, pornography, this we have almost covered. Okay. Vishal, hello, hello. Can Vishal hear
Yes,
me?
sir.
If I need a 5-10 minutes break, I'm searching for that one particular presentation that is
Yes,
somewhere
sir. Yes,
missing.
sir.
So
Yes,
let's
sir. We
take a
can take.
break and then we
Now
can.
it's I think 4:43, right?
Yes, 5:43.
Yeah. So we will start at.
Okay, done. I think we can go ahead with this.
Sir, have you got the PPT? Anybody call Saket sir and ask for that as is he got PPT or not?
Hi, Vishal. Hello.
Yes, sir, you're audible.
Okay. I believe I'm not finding that PPT, and it will be wrong to take a class without that presentation. Can we wind up for this day? I'll cover it in the next class.
Okay, sir, not an issue. We will.
Okay. Sorry for this particular mishappening that has happened. We'll
Uh,
cover entire stuff next time.
yes, sir. And what about presentation link?
Beg your pardon?
What about the presentation link?
That how do you want to take it up? Means if I'm not attending, taking up the session now.
So, sir, if you have the group on the WhatsApp, so they can share the link over there also.
It is the same thing with you as well, na?
Yes,
Hello.
yes, sir. I'm talking about the presentation link.
So how do you want me to take it up?
So then, if you have the group and you have the same students over there, so you can share your presentation link over there. So student will.
It's not. I'm sharing the presentation. Means attendance list.
Okay,
It
not.
is it is shared by somebody else.
Yes, sir. Okay.
Okay. Sorry for the delay, students. I think I'll try and cover entire stuff in the next class. Thank you for the day.